right, everyone. Thank you for tuning in to the Honest Defense Podcast. Today, I'm honored to be joined by Professor Randy Barnett. Professor Barnett is the Patrick Hotung Professor of Constitutional Law at the Georgetown University Law Center, where he teaches constitutional law and contracts, and he's the director of the Georgetown Center for the Constitution. Professor Barnett has also written 11 books, including Restoring the Lost Constitution, The Presumption of Liberty, which was a major influence on me when I was in school. He wrote Our Republican Constitution, Securing the Liberty and Sovereignty of We the People, which I actually just ordered. I just started reading it. And he also recently wrote An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know, which is what we're here to talk about today. And he co-wrote that book with Professor Josh Blackman. Professor Barnett, thank you so much for joining me.
Well, it's a pleasure to be here. Thanks for having me.
So before we get into the book, I want to start with you because you're a very unique academic. Most academics, kind of the stereotype is these button-down people in the ivory tower. They're focused solely on their research. And I mean, you're well respected in the field. You're one of the most cited constitutional law scholars in the country, but you're active on Twitter. You've given talks to all sorts of different groups. And I was curious about how you developed that sort of public persona. Did you always intend to be a public figure, or did you want to be a researcher first and somehow got dragged into the public sphere?
That's really a good question, Eric. I have to think about it for a minute. Sure. I do know when I was very young, I wanted to go into politics. So I guess that would have meant that I had and I did speech and debate in high school. But by the time I realized what a professor was, which was in college when I took philosophy, and I had a very influential philosophy professor that had a big impact on me, I decided I wanted to be a professor. And to me, being a professor means being a scholar. And so my scholarship, my academic research is my most important activity for me. And the reason is because I want to make a contribution and to making the world a better place. And I think the way I can do that as one person is I can discover something that's true that other people haven't seen. And if I publish it, it becomes sort of part of the permanent record for anybody like you or anyone else in years to come after I'm gone to discover and to think about. And so that's how I make my permanent contribution. And that's why my scholarship comes first. And it happens to be something I can do. I mean, I think everybody should do what they can do. And this is something I think I can do that other people can't do. On the other hand, I do enjoy engaging with the public. And I have done so for a very long time. And I suppose the most active engagement was when I was litigating the Gonzalez versus Raich case, which is the medical marijuana case. This would have been in the early to mid 2000s. I argued that case in the Supreme Court in 2004. The case was decided in 2005. So I did a lot of media associated with that case. And then later on, when I was instrumental in developing the idea of why the Affordable Care Act was unconstitutional, I did a lot of public stuff at that point. And one of my specialties, it turns out, was to convert complicated ideas to manageable sound bites that the public could understand, but at the same time would be faithful to the idea. They wouldn't distort the idea. And so I became good at operating at two different levels. One is the level of theory and scholarship and detail and complexity. And the other is at the level of being able to reduce that to an idea that's simple enough for or other people who are not scholars to understand. Like, for example, take originalism. There's a lot that have been written about originalism. You mentioned my book, Restoring the Lost Constitution, has several chapters on originalism. But yet I think that originalism can be boiled down into a single sentence. And that is that the meaning of the Constitution should remain the same until it's properly changed, which is by amendment. That's one sentence that I think everybody can understand to describe a very complicated theory. And I think it's a test of a theory, frankly, that it can be reduced to simple formulations because it shows that it's onto something that's true. If it can't really be explained, then there's a good chance it's actually not true.
Do you think that academics should be more focused on trying to engage the public in their ideas? Because it seems like that's part of the disconnect why so many people have such antipathy towards academics, is that it's such an insular profession, and it seems like they spend all of their time kind of arguing back and forth over these minute issues when the public has these real issues going on. Should there be a bigger attempt at academics at reaching the public?
Well, I mean, I want to insist that those issues that we academics debate and discuss are important ones. The subtle issues, the technicalities, they're really important. And I think as to whether an academic chooses to engage with the public, number one will depend on his own or her own personality. And I don't think people should do something that goes against their personality. And many academics become so because they're kind of inward and they want to spend time in the library and they want to spend time writing and they don't really want to project. And I think that's fine. That's perfectly fine. And also, there are subject matters that they're not conducive to engaging the public with. I was a contract scholar,
Right.
doing the theory of contract law for many years before I really segued into constitutional law. And I can tell you, as interesting as I find that subject, the general public does not. And it would be very difficult to attract 38,000 Twitter followers just tweeting about contract law or contract law theory. Excuse me, just hit my laptop there. So it's really a matter of preference, and I get it. I enjoy both, and also I have to say, like teaching, when I teach, even though teaching is to some extent a duty, it's some extent a chore, especially exam grading is a chore. But having to explain what I think to students keeps me honest, and it actually stimulates my thinking. When I have to reduce my ideas and I have to explain them to other people, I find that, well, wait a second, maybe I didn't understand that really as well as I thought I did. And I think the same thing is true with explaining things to the general public as well. It keeps you honest. And I think it's useful if you're in a field which is conducive to it, which is not every academic field.
I think it's an Einstein quote. It might be apocryphal, but he said something like, if you can't explain your idea to a 12-year-old, you don't really know it. I think that's the idea you were trying to.
It's exactly right. Although, I think I don't aim at the 12-year-old audience.
Right.
I kind of aim at the people that are sort of more mature than that.
Right.
But I think that's one of the reasons why my Twitter feed is popular, is because it's aimed at the right level. And the book that you just held up, both of the last books you talked about, Our Republican Constitution and 100 Cases, the Introduction to Constitutional Law, they're both aimed at a general audience.
Right.
Restoring the Lost Constitution was really not aimed at a general audience, and you read it anyway. It was really aimed at more of a college student or a law student or a law professor, whereas Our Republican Constitution was definitely written for the general public and had to be rewritten when my editor thought it wasn't accessible enough to the general public.
Oh, interesting.
And then 100 Cases and the video series that accompanies it are really specifically meant for people at all ages, down to homeschooled high school students.
What was it that the editor thought wasn't accessible? Was it too much legal jargon, or?
I didn't know. It worried me. I was having dinner with my editor in New York, or celebrating the contract, and I thought I was done with the book. And he said, it's just not accessible enough. So I thought, oh my God, I wrote it as clearly as I can write, and I'm generally known to have clear writing style. My prose is considered to be clear. I said, I don't know how I can make this prose any clearer. So I said, what would you advise? He says, well, it needs more stories. I said, oh, okay, well, I can do that. So then I went off and I went and found an individual story of some kind to start each chapter. And it was either a story from history, or it was a story from current events, or it was my own personal story, a little anecdote about myself. And then I found when I started every chapter that way, I realized that my chapters weren't necessarily in the correct order to tell an overall story. The whole book was bouncing back and forth from era to era. And so I rearranged the chapters. And that meant I was telling one continuous narrative, punctuated by individual stories. I turned it back in again with my fingers crossed that he would be satisfied with it, and he absolutely was. He says, you nailed it. So it turns out it was not my prose, it's stories. And I really do think stories are the best way if you can do it, stories are the best way to communicate ideas, if you can tell your ideas in the form of a story.
And that's what I loved about the Introduction to Constitutional Law, is that with each case, you tell a story about the people involved in the case. And I think that often gets lost, especially in law school. When we're reading these cases, you forget that there's people behind it. You're just looking at the law. And the great thing about your book is it taught constitutional law the way I expected it to be taught when I was starting law school, which is it's this history of America and of the people in America. And I was curious where you got the idea of making a more accessible constitutional law book.
Well, my casebook was always a narrative from the beginning to the end. Unlike casebooks that are organized doctrinally, my casebook was organized as a narrative. My co-author, Josh Blackman, I brought him on to help promote the casebook because he's kind of an academic hustler in a good sense. And the casebook sales needed some boosting. And I brought him on to do that. And he thought, well, let's do a video series that would talk about these cases. And I said, sure, that's a great idea. I didn't realize it was going to take 2 years and cost close to $100,000 to produce these videos.
Right.
But the videos were initially intended just to illustrate the casebook. But as we were halfway through this enormous undertaking, and I realized how enormous the undertaking was, I thought that's not enough people to justify all the work we're doing.
The casebook meaning the standard book that law students would be reading in their first year of
Exactly.
law school.
Right. And that depends on a law professor choosing to use the casebook. Students don't pick the casebooks, the professor does. And frankly, not enough professors were picking my casebook to justify the work we were putting into making all these videos. So I thought to myself, what can I do to bring all this work to the attention of a broader audience? And so I know what we can do. Let's take the scripts for the videos and turn this into a freestanding textbook.
Right.
An introduction to constitutional law, 100 Supreme Court cases everyone should know. And then you get the book, then you get the videos along with the book. And that will make all the effort we're putting into this worthwhile. It would make it pay off. And it really, really has. That book has sold enormously well. The publisher is beside itself, it way exceeded the publisher's expectation for what a book like that could sell. And the feedback we've gotten on Amazon and also on Twitter and elsewhere has just been enormous. And I think it's only going to grow as that book starts to be used in advanced placement courses in college and in homeschool classes in high school. And in fact, we're even going to add a chapter on criminal procedure because so many of the undergraduate advanced placement courses cover criminal procedure, even though most con law casebooks do not.
Right. I was actually going to ask you about criminal procedure. I was going to ask you why you left out some cases like Miranda, bigger cases, and I assumed it's because in law school it's a separate course. Exactly,
and it all grew out of the casebook, which is aimed at law school. But we are going to put a chapter in our casebook because we actually want our casebook to be adopted for undergraduate con law classes, and they cover Miranda and others. And I'm a former criminal prosecutor, so I had to know that stuff when I actually was in the criminal justice system myself. So it is not foreign to me to deal with that material. So we're going to add a chapter to the casebook. We're revising our casebook right now. In fact, we're nearing the end of the revisions, and we're just at the point where we need to write this last chapter. And then we're going to come out with a new edition of 100 cases, which will add a component on criminal procedure as well.
That's great. Do you think there's something fundamentally different about constitutional law relative to other courses or other areas of law? Because again, before I started law school, I didn't know any lawyers. I didn't know anything going into it. I was most excited about constitutional law because I loved history, and I thought we'd be learning about the founding of the country, about the writing of the Constitution, about the meaning of the words when they were written, what the founders were trying to do. And when I got to school, and I had a great professor, but this is just how every con law course is taught. We spent maybe 15 minutes the first day of class talking about some of the history of the Constitution, and then you just go into the cases the same way you would in any other class. You're just reading cases and how they build on each other and not referring back to this original idea of the Constitution. Do you think that needs to be changed? Should there be more of this foundational understanding of the meaning of the Constitution?
Well, to answer your first question, I
asked you a couple questions in there.
I think con law is different. When I teach contracts, I don't teach it as a narrative. When I teach contracts, I teach all the classic cases, and each one of them are very interesting stories.
Right.
And that's one of the reasons that makes the classic contracts cases so fascinating, is because they are stories that grip the imagination. That's how they came to be classic. But it's a series of individual stories about doctrine. In con law, in contracts, you're really teaching the doctrine. What is the doctrine of consideration? What is the doctrine of promissory estoppel? What are the defenses of fraud, mistake, unconscionability, et cetera? That's what you're teaching. Contract formation. These are done by rules. The rules are either in the restatement of contracts or they're in the Uniform Commercial Code. You find them. That is not how constitutional law is practiced. I'm not talking about in theory, I'm talking about in practice. In practice, constitutional law is practiced according to these canonical cases.
Right.
The canonical cases are the good ones. The anti-canonical cases are the bad ones. But what makes the good case good and what makes the bad cases bad is something you can only understand in the context of a narrative that starts at the founding and comes to today. And so you have to understand the story to know why the approved cases came to be the approved ones and the disapproved cases came to be the disapproved one. And it's easier to understand and to remember if you learn it as a story. But that's not, as you say, how it's normally taught. It's how my casebook is structured. And my casebook structured the same way as the Introduction to Constitutional Law cases, 100 Supreme Court cases is structured. It's the same structure. One follows the other. But that's not how it's generally taught. And unfortunately, I haven't been successful enough at recruiting law professors to teach it my way. I think all they'd have to do is try it, and they would love it. But they look at a casebook like mine and they go, well, that's a lot of history, and I don't know. It's not how I learned it. And so they just don't do it. And that's the reason why we kind of had to go over the heads of the professors to create this book that any student could buy for under $30 to supplement the way they're learning it in class. Because you can watch all our videos that tell you the story while you're studying the cases out of context, so to speak, in your class.
How do your students respond to that narrative structure? Because I think in some ways I was the outlier in wanting that narrative structure, because a lot of my classmates, I remember, were frustrated enough with the way con law functioned narratively. They liked the hardline rules of civil procedure, of contracts, because it was easier to study that. It was easier to know what the right answer and wrong answers were. How do your students respond to the way you...
Well, that is a standard student attitude towards law school generally.
Right.
Just tell me the rules. I came here to learn the rules, right? But I can tell you that once students are exposed to the narrative, they become really a believer in the concept. Because first of all, it's just inherently interesting. And I think all things being equal, students would rather be interested than bored. And secondly, what they find as they get about halfway through the class, and really at that point, we're in the second half of my class is all contemporary stuff. They can understand the contemporary stuff, the current doctrine better because of what they learned. And every practitioner of constitutional law knows that story. They got it in their head, and they got it somewhere. If you can pick it up in con law classes by this note and that note and this note and that note, but it's confusing because it's not coming at you in chronological order. It's coming at you in some doctrinal order. So you're jumping around like my book jumped around. Your casebook is jumping around like my book jumped around. But if you put it all in order, it makes so much more sense. And then the students, I think, really, really like it. And I have to say, I benefit from the fact that I actually litigated in the Supreme Court, and they trust me to tell them that this is what a practicing lawyer needs to know. If I hadn't done that, they might not trust me. They might say, well, this is just what he likes. But I can tell them this is what I needed to know when I practiced in the Supreme Court, and when I and when I do, and when I like we just had a new case come down a week ago or 2 weeks ago on COVID restrictions in New York that the Supreme Court handed down, and it was in the last week of my class, my Con Law 2 class, and I sent the case out to the students. And I edited it down to about 10 pages. I sent the case out to the students. I said, we're going to talk about this the next class. And then I came in, I said, look, the first thing I hope you saw when you read this case is you understood what they were talking about. You knew the citations that they were making. You knew why they were citing to them. That you knew why the majority and the dissent were disagreeing with each other. You could plug this in to the overall structure because of what we learned in this class. That shows how far you've gotten in this class just from 3 months ago to today. Because that's what a constitutional lawyer needs to know. They pick up a case, they go, oh, yeah, I get what's going on here. Because that fits the story, that I understand it. And really, and by the way, the story isn't of just one opinion. The story is of competing opinions. There's usually two sides. Throughout history, there have been two sides of everything, or maybe three, but usually two. And so to understand the narrative, you have to understand both sides, and I have to teach both sides. So when you pick up this case, you say, okay, I get what the majority is doing here. I also get what the dissent is doing here.
Right.
And after just 3 months of con law, they can get that. And then I think that proves to be very satisfying for them.
And I think what's great about your book is that you're showing you don't have to be a constitutional lawyer to understand what's going on. You can read a Supreme Court opinion if you have a high school education and know what they're talking about. Maybe you don't know all of the precedents they're talking about and you don't understand the citations, but you can understand the ideas. And I try to tell people that to be a lawyer, you don't. I have friends who are engineers. I have family who are doctors. I said, those people are actually smart. Lawyers aren't that smart. They have an 11th grade education and they just sit down and they read a lot and they write a lot. Anyone can understand a case if you put in the time.
Well, I don't like to disparage lawyers like other people do, with lawyers' jokes and all this kind of stuff. And actually, I once got chewed out by a judge when I was trying a case. In closing argument, I accused the other side of engaging in cheap lawyers' tricks as a prosecutor. And after I did the argument, the judge took me into chambers and he chewed me out. And he said, "You should never disparage the profession of law that way." And I took that to heart, actually. In fact, that case was reversed because of what I said. So that's another reason I took it to heart. Although if the judge had simply sustained the objection to what I said, the case would not have been reversed. He overruled the objection, then he chewed me out privately. Judge, if you're so smart, just sustain the objection and the case is saved. But never mind that. Anyway, I think he was right. And I try to avoid doing that. I think some lawyers are smart. We have a certain kind of training that other people don't have. And that's what it means to go to law school and think like a lawyer. And that is something that the general public has a hard time with. They can't replicate. There is a reason why you went to law school. There's a reason why you were trained. There's some things you can do the general public can't do. However, when it comes to constitutional law is a big story. It just is. Unlike contract law, unlike corporations, unlike taxation or whatever, name a million subjects that are not a story, very hard for people to get into. This is a story. Told properly, everybody can understand enough of this story to know where we are in the United States. And that's one of the things that makes teaching constitutional law so much fun and writing about it so much fun, in a way that, frankly, teaching contract law, as interesting as I thought that was and still do, it's just not as fun.
Right. So you brought up Gonzalez v. Raich. It's a case that you listed in the book. You argued it in front of the Supreme Court. And it was, like you said, it was an early medical marijuana case from 2005. I think it really started this ball rolling of marijuana legalization that we're seeing now. I was curious how you got involved in that case in the first place.
It's a long story, but I'm old. That's why all my stories are long stories, unfortunately. I got involved in that case when the lower court judge in a different case involving the Oakland Cannabis Buyers Cooperative, and he was Justice Breyer's brother, Charles Breyer, on the district court in the Northern District of California. He asked the parties to that lawsuit, the lawyers, to brief the Ninth Amendment. And the Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. It was a Commerce Clause challenge, but he asked them to brief the Ninth Amendment. So they went around, one of the lawyers, Robert Raich, was his name, went around the country looking for a lawyer, looking for an expert on the Ninth Amendment. Well, I happen to be one of the nation's leading authorities on the Ninth Amendment. There aren't that many who were, and I was. And he came to me he called me up. I remember I was in my office at Boston University. He called me on the phone. He identified who he was. He told me what he was doing, and he asked me if I would be willing to help. And he told me what the case was about. And sure enough, it really was Ninth Amendment. He was right. Usually when people bring up the Ninth Amendment, it really doesn't apply. But in this case, it did. So I started helping out the case by helping him write that part of their trial brief, which went nowhere. Ninth Amendment stuff never goes anywhere. But now I was hooked up with the case. I was connected up with this Commerce Clause challenge. Eventually, there was a problem with that case in pursuing a Commerce Clause theory, because in the Oakland Cannabis Buyers Cooperative, people go into that building with money in their pocket and no marijuana. They come out of the building with less money in their pocket and marijuana. That means money and marijuana are changing hands. And you know what we call that? We call that commerce. So commerce is happening. Now, it's intrastate commerce, not interstate commerce, but it is commerce. It would have been much better to have a case that had no commerce at all. So my co-counsel, Robert Raich, said, would you be willing to bring a lawsuit, you and me, bring a lawsuit on behalf of somebody who is not buying and selling marijuana? And as it happens, the somebody was his wife, Angel Raich. And then we had another plaintiff, Diane Monson, and that brought in the third lawyer, and the three of us brought the lawsuit on behalf of Angel and Diane to enjoy. It was a civil action in equity to enjoin the application of the Controlled Substances Act to them because they weren't buying it, they were not selling it, they were growing it for themselves, and so no commerce was involved, nothing interstate was involved, and we brought that lawsuit. So I actually brought that case because it was a case of better facts. And we lost in the district court. We won in the Northern District. We won in the Ninth Circuit, and then we lost at the Supreme Court by a vote of 6-3. I must stress, we got the votes of Chief Justice Rehnquist, Justice O'Connor, and Justice Thomas, but we lost the case when we lost the votes of Justice Kennedy and Justice Scalia, and we never had a shot at the progressive judges on the left side of the court.
Were you surprised that you lost to Scalia and Kennedy?
Not after oral argument, I wasn't.
What happened during oral argument? Was there any?
They telegraphed their sentiments in oral argument. Now, Kennedy was sort of outright hostile to me in a way that he normally isn't. So that was bad. Scalia was nicer to me than he sometimes can be. He could be pretty nasty. And he wasn't nasty, but boy, he was tough, substantively tough. I had my hardest time answering his questions. And after that, I knew that I had not, I thought I had done well. In fact, you can listen to my argument on oyes.org, which is a website. Just Google that and you can listen to my oral argument. I thought I did fine for the first time in front of the Supreme Court, but I really didn't think we'd won. And in the months between arguing the case in December and getting the result in June, you sort of could talk yourself into the fact, well, you don't really know from their questioning which way they're going to do. Maybe they would really just be, well, it turns out I was right. We lost the case.
I've always been curious because you have to be admitted to the Supreme Court bar to argue in front of the Supreme Court. What's the process for actually getting admitted to that bar?
It's not that hard.
Oh, really?
You just have to apply and be vouched for by two members of the Supreme Court bar.
Okay. Oh, that's easy. That's easier than the regular bar. I should have just done that instead.
Yeah. Actually, the funny thing is that as I was working with him on the Oakland Cannabis Buyers Cooperative case, I was in California to give a speech, and we were driving in his car with Rob Raich, my co-counsel, and he said, "Are you a member of the Supreme Court bar?" And I said, "No, I'm not." He said, "Well, you should join the Supreme Court bar." I said, "Why?" He said, "Well, because you're going to argue this case." I said, "Rob, the case isn't going to the Supreme Court. If it does go to the Supreme Court, I won't be the one that argues it." It turns out the case did go to the Supreme Court. I was not the one who argued that case, thankfully, because we lost that case 8-0. I would not have done any better, and it would have been horrible. But he was right. I was the guy who argued the next case. And so that's how I joined the Supreme Court bar.
So that case is kind of unique because Rob Raich was a lawyer and he was actively involved in the case. But in a typical case at the Supreme Court, how involved are the actual people involved in the case?
Well, Angel Raich. I mean, actually, let me go back to the previous thing you said about how this was the beginning of the sort of the growth of the medical marijuana movement, which has now, blossomed all over the country. This was much to my surprise. I mean, I thought, you lose the case, there goes the medical marijuana movement. But that's not what happened. The medical marijuana movement took off after that. And I think the case had a lot to do with it, because when I started dealing with this in the late 1990s, when I tell people about what I was doing, they say, "Really? That sounds kind of crazy and kooky and, weird." By the time I argued the case in the Supreme Court, that's not what people were saying. They were saying, "No, this is real. This is serious. This is legitimate. You should win." I mean, a lot of people said, "You should win." They were disappointed when I lost. So it went from off the wall to on the wall in the course of that period of time. And the other thing that was super important is it provided a platform for my client, Angel Raich, to seek to do publicity about medical marijuana. She was an avid person who loved publicity. In fact, she wanted, oh gosh, I just drew a blank on the guy's name. I'm going to have to come back to that story because I can't tell the story unless I tell you the guy's name. So she avidly sought publicity. She loved it. And so she became a spokesperson for medical marijuana, and so she was interviewed all the time, and that helped legitimate medical marijuana as well. So this shows you that even a losing lawsuit can bring an issue to public's attention and change public opinion, even though you lost.
Well, eminent domain is one of those issues as well, right? With Kelo v. New London, that actually empowered states to use eminent domain, but there was such a public backlash that a lot of states then adopted legislation against eminent domain, right?
Right, although unfortunately a lot of the legislation was kind of toothless.
Oh, really?
Yeah, I mean, so
So
some of
maybe
it's
that wasn't the best example.
no, it's a good example because it did, and it moved states. Look, the fact that it moved states even to adopt toothless legislation shows that they were responsive to public opinion.
When you were walking up those Supreme Court steps to argue, I'm just thinking back to when I first moved to D.C., my first internship there, and I come from a small old steel town, and when I first showed up in D.C. and I'm doing my daily runs along the National Mall among these monuments, and even being a libertarian, I'm not supposed to be impressed by all this, but I still had this holy shit, I can't believe I'm here. I'm in D.C. and I'm working here. I'm talking to congressmen. Did you have that moment when you were walking up those stairs to argue at the Supreme Court that just this surreal, was there a surreal feeling that I'm arguing in front of the Supreme Court right now?
It was very surreal. You don't walk up the steps though to get into the Supreme Court. You walk down the steps after you've argued, but you don't walk up the steps.
That's right.
You actually have to enter into a side entrance, and then you go up to the lawyer's lounge, and then from the lawyer's lounge you walk into court. So you don't have that moment. You have the triumphant moment walking down the steps to get to. There's a set of microphones that are set up where the press is, and you have your press conference on the step on the plaza in front of the Supreme Court. That's very cool as well. But absolutely, it was totally surreal. And I have to tell you that I was extremely anxious for 6 weeks prior building up. In fact, I was so nervous that I could understand how people in high pressure jobs get ulcers, because I could imagine, because I had this thing in the pit of my stomach for 6 weeks as I was doing moot courts and everything. And it was getting worse and worse. The night before the argument, I was having dinner with my best friend, who was actually sort of my best man getting me through this process, another law professor. And at dinner, we went out to a movie the night before to try to take my mind off of it. He'd been grilling me, all day long. We went out to a movie, and we were at dinner, and I said, it would be a real problem for the case if I'm as nervous tomorrow as I am tonight. The next morning, I woke up, and I wasn't that nervous. And then I said, well, maybe when I get to the court, I will be. And when I got to the court, I wasn't. I said, well, maybe when I get to the lawyer's lounge, I will be. And I wasn't. And I thought, well, maybe when I get inside the courtroom, I will be. And I wasn't. It felt a lot more like what it felt like to try a murder case in front of a jury than anything else, which is obviously you're amped, you're psyched. You are a little bit nervous, which is a good thing, frankly, because it gets your adrenaline going. It gets your mind working.
Right.
But I wasn't freaked out. And I think the reason why is because I think I felt prepared. And what really gets you nervous is when you feel like you're not prepared. So, but I was in awe of the situation. And I think if I were to argue, I don't ever plan to argue again. I don't aspire to do it. My wife doesn't want me to do it. The pressure is just enormous. But if I ever did do it again, I don't think I would be as in awe because, for one thing, I now know all the justices. And I respect them, and it's not that I don't look up to them, but I know them. I mean, I've talked to them, and so they're not as scary to me as they were when you just know them by their images and by their reputation.
So going back to the book, obviously your case was going to be in this book, and it was an important case. It stands on its own. But how did you go about picking the other 99 cases to include?
Well, it really wasn't that hard because it's the cases that were in the casebook. And those are the cases that I think you need to teach the course. So, if I could let you in on a little secret, there are actually 103 cases in the book, but 100 cases sounds better. And there's going to be a lot more cases in the next edition. So I don't know what we're going to do with the title. It was just, these are just the core of a basic constitutional law class. Which is why, to go back to your earlier question, why there's no criminal procedure stuff there, because that is not the core of a basic constitutional law class. So maybe it should be, it's not. So that's how we came to pick those cases. And let's just put it this way. They are not the only cases, Supreme Court cases, the public should know, but they are 100 cases that the public should know.
Right. Are there cases in there that you thought might be less known to the public, but you said this has to be in there? We have to have a good explanation. People should know about this particular case.
Well, it's because first and foremost, this is a book for law students who need to know these cases for their constitutional law class. That's our number one market. Right. Is students who are taking constitutional law and want background materials on the cases. So, and a lot of those cases are obscure to the general public. But I think if properly told as stories, which is what we try to do, they're all interesting. Even the ones that are obscure, if you actually get into the story of what happened, they're interesting too. And that's the object, is to make it interesting by making it into a story.
Should people care more about some of the more procedural cases? The cases that make the news are always the ones dealing usually with individual rights, First Amendment, Second Amendment, 14th Amendment. But, you have a case in here about the presidential power to make recess appointments. That's something that might not grab the public's attention, but is that something that they should be caring more about?
Yeah, I think that the public should be a lot more aware of the structural features of the Constitution, which are really what mostly protects us. And to the extent they've been overridden, that's where the problems have been over our history, because a lot of these structural provisions have been ignored or disregarded by first by Congress and then by the Supreme Court letting Congress do it. And so those are the most important things. They're also the ones that stick more than protecting rights do. So, for example, the fact that the bill has to be approved by both the House and the Senate, that sticks. That the president can veto it, that sticks. That's something that people try to get around that, but that's a very sticky thing that stops bad things from happening. Also, sometimes stops good things from happening. But it's a barrier, and the more things that you know about, those are the things that really protect our liberties. And the Bill of Rights, or what we call the Bill of Rights, which, by the way, what we didn't call the Bill of Rights until the New Deal, as I talk about in the other book that you have there. Those are secondary to what protects us. And in fact, just look at the latest COVID thing. There's not that much there that protects us. I think what's happening with COVID is that a lot of the structural stuff has been overridden. If you have governors unilaterally making laws that are going to put people in jail or affect their livelihood or take away their businesses without benefit of legislation that was actually passed by a legislature, because they're doing so pursuant to some emergency powers they may or may not have, that's a big problem for liberty. That's a big problem. If the legislature has to legislate, and I could understand why in the beginning of an emergency, measures have to be taken, quickly. But we're not at the beginning of this emergency. We're way into it now. And there was more than enough time for legislatures to deal with this question and for the emergency powers to expire. But the problem with recognizing emergency powers historically is that once you have them, they never expire.
If you were a betting man, what are the odds that one of these cases about these lockdowns go to the Supreme Court and end up being struck down? Whatever powers that the states have used to enforce these lockdowns, what are the odds that they are deemed constitutional? Well,
I learned, starting when I was doing the Raich case, that I don't make predictions about how the court will rule. And I can tell you that's what every member of the press wants you to answer. They say, well, how will the court rule on this and how will the court rule on that? And when you're litigating a case, you don't want to tell the court you don't want to tell the press how you think the court will rule, especially if you think you're going to lose, because the chances of us actually being able to overturn the Controlled Substances Act when it comes to medical marijuana was always a long shot. So I don't want to. I think I want to be honest with the press.
Sure.
I always want to be honest with everybody, and I don't want to say, oh yeah, I think we're going to win when I don't think we're going to win. So I adopted a policy of never predicting the outcomes of cases. I just talk about the merits of arguments. I talk about what arguments ought to win, or whether arguments are reasonable or not whether they're going to win as a predictive matter.
I retract that question then.
Well, I wanted to make a general point about
it. So it's easy to become cynical when you're reading about constitutional law. Because it feels like a lot of times the court's ruling based on politics, so either their own politics or the politics of the day, and then they go and try to reverse engineer the legal justification for their decision. Can you talk people off the ledge, people like me who I read this stuff and I get frustrated? Can you talk people off the ledge that there is some sort of principle that runs through these cases?
Well, to some extent, I don't want to talk you off the ledge, because to some extent it's true. This idea that you talked about is called legal realism, where the legal realist, to put it simply, is the idea that judges reach their conclusions based on what they want to do, and then they only use the legal reasoning after the fact as a rationalization for what they already wanted to do. I think that generally is not an accurate description of how most judges decide most questions. If it's accurate anywhere, It's accurate at the Supreme Court level in constitutional cases. It's not even as accurate. It's not even that accurate with lower courts, who generally speaking try in good faith to follow what the Supreme Court has previously said. They feel they're bound by precedent. It's the Supreme Court who isn't really bound by precedent, no matter what they say. They really aren't. They're the ones that fit this description more than any other judge. So there's some truth to it, more truth to it in con law at the Supreme Court level than in any other field. But even saying that, I think it's wrong and inaccurate to say what the judges are doing is simply reaching their policy outcomes, their preferred policy results. Because if that were true, we would have won the Raich case, or at least we would have gotten the progressive side's votes, because we had the progressive policy argument. We had medical marijuana. We had sick people. We had won. The liberal Ninth Circuit had ruled for us, and it was the liberal judges in the Ninth Circuit who ruled for us. So we should have won that case, but we never had a chance at the left side of the court. And who did we? And I'll tell you why in a minute. Who did we get? We got 3 conservatives. And Justice O'Connor, in her opinion in the case, said if she were a legislature, she would not have voted for this law. Justice Thomas refused to join that part, which I thought was interesting. So what was going on? And that was each side of the court was putting their principles ahead of their policy preferences. That may not have been true, by the way, for Justice Kennedy, but it was true, I think, for the rest. And the principle of the left side of the court is strong national power. That's the principle. That's the constitutional principle they believe in, even where it goes against the written Constitution. They believe in the necessity and propriety of strong national power. Our case was a challenge to that. And if they ruled for us, they would have other cases challenging strong national power they don't want. And by the same token, I think what Chief Justice Rehnquist and Justices O'Connor and Thomas were believing in was limited and enumerated powers and the rights of states to make their policies, their own individual policies, which is another structural thing, part of the Constitution. And they were voting that principle. So I think these, and our book, 100 Supreme Court Cases, is about that. It's about how the principles of each side have evolved and how they clash. The principles of one side versus the principles of the other side. It isn't just about ruling for Republicans or ruling for Democrats or ruling for left-wing policies or ruling for right-wing policies. It's not unrelated to those things, but it's different. There's an intermediary. These justices think of themselves as, and I think they are, to a large extent, principled. It may be sometimes hard because of what their principles are to reconcile that with the cases and with the precedents, because these principles may not all be correct. That strong national power principle may not even be a good principle, but it's a principle that you can respect. And I think that's the extent to which I want to talk you off the ledge.
Good.
Does it help?
It helps a little bit, but I have a follow-up, because it also seems that one of the themes of the book and of constitutional law in general is that we see this expansion of social liberties, of personal liberties. At the same time, we see a contraction of economic liberties. And I mean, you can look at one of the few cases that actually expanded economic liberties was Lochner. And when you talk to anyone now in the legal field, you bring up Lochner, they rank it up there with some of the most evil Supreme Court cases that have ever been decided. And I'm wondering where you think that split comes from. Is that something structurally in the Constitution that created that rift? Is it the types of people who are making these decisions? Why do you think we've seen such an expansion of personal liberty and such a restriction of economic liberty?
Well, Lochner is in what I call the anti-canon. I mean, it's in the anti-canon for progressives. It's in the anti-canon for conservatives. In his dissenting opinion in the same-sex marriage case of Obergefell, Chief Justice Roberts invoked Lochner some 17 times to accuse the majority of engaging in what Lochner was doing, what the Lochner court was doing. Now, we could probably try to explain to your audience what the Lochner case is. That might take a little bit of doing. But it was about the constitutionality of New York passing a maximum hours law regulating how many hours a baker could work, a bake shop employee could work in a bake shop. And it maxed out at 60 hours a week, which is a lot. And it was challenged on the grounds that it was not a genuine health and safety law. It was actually a labor law. And the challenge was sustained 5-4, that it was unconstitutional because it wasn't a genuine health and safety law. That was actually part of a very big health and safety regulation of the bake shop industry, which was upheld and was not questioned. We talk about all this in the book. There's a whole video about this also. So that's what Lochner was about. But with the New Deal, Lochner was greatly criticized originally by President Theodore Roosevelt. I tell this story in our Republican Constitution. He gave a big speech at Carnegie Hall when he was running for the progressive nomination. This was after he was Republican president, then he left office, and then he ran on the Progressive Party ticket, or for the Progressive Party nomination. And he attacked the court for the bake shop case, and he praised Justice Holmes's dissenting opinion in the bake shop case. He had put Holmes on the Supreme Court when he was president. And so that was the first time Lochner came to be criticized, but it was largely forgotten. It's very famous today, but I actually thought, there's another example about how narratives are strange. I thought when I was a law student in about I took con law in about 1975. I started law school in 74. It's a second year requirement at Harvard, so it was in the fall of 75. Gerald Gunther had just come out with a new edition of his Casebook that year, which is what I had. And in it, Lochner was very prominent. And it was in a unit called the Lochner, referring to the Lochner era. Well, he'd only first introduced Lochner into this Casebook in the previous edition. And before that, it was so obscure that in Griswold versus Connecticut, which was the Connecticut contraceptives case in 1965, when one of the advocates made a reference to Lochner, one of the justices, and I forget which justice it was, I think it might have been Justice Black, you listen to the oral argument, he's not sure what case that is. He says, is that the case involving the size of bread loaves? There actually was a case about regulating the size of bread loaves. So he was kind of right. It was about bread.
Right.
But that shows that in 1965, a Supreme Court justice couldn't quite place the case. So what does that tell us? It tells us that Lochner being sort of the epitome of the evil case, which it is for many people, it's a relatively recent development. It didn't have that same cultural resonance. It was a bad case. Once the New Deal repudiated it for sure, but it wasn't like it wasn't so famous. It became famous because I'll get back to where we started. Con law is told as a story, and Lochner is a bad actor in this story. So, but that story changes over time.
But why is it that Lochner and those cases are considered such bad actors? Why my original question is why is it that any of these cases that seem to expand the freedom of contract are just derided in the legal industry, the legal field, while we have case after case, we have Obergefell, we have all these cases that have been expanding social freedom, and I'm trying to bridge that divide. Why is it that we've grown freedom in so many areas socially, but we've restricted them when it comes to freedom of contract specifically?
By the way, I'm moving around like this because I'm trying to get the sun off my face because I know I'm glowing white here with the reflection of the sun, right? So this has to do with what's called the New Deal revolution, and that is that the regulation of the national economy was imperative. It should be done by the Congress, regardless of whatever limited powers Congress may have had under the Commerce Power, the Necessary and Proper Clause. This was necessary. The Constitution should not be allowed to stand in the way of that. Some people argued it was consistent with the Constitution. Most people argued that even if it wasn't, it doesn't matter. We need a living Constitution to respond to the times. This was essential. And so if you're going to let Congress regulate economic liberty, you don't want judges second guessing them. And that was the general principle. Now we're talking principles again. That was the principle. Then in 1965 with Griswold versus Connecticut, the court now is going to protect the right of privacy, in this case of married couples to use contraceptives. It was soon expanded to be unmarried people using contraceptives. Where's that coming from? Well, it's coming from the sexual revolution. It's coming from the women's movement because it provides independence for women. There's lots of social aspects of where the use of contraceptives are coming from. Where is it coming from constitutionally? Well, what the court, I think, was then tried to do is they say, look, you got to protect the power of the legislature to regulate the national economy because that's paramount. But that's different than this personal liberty stuff. Personal liberty stuff is personal liberty. Protecting personal liberty is not going to stop Congress from regulating the national economy. It's not going to stop states from regulating the economy. So we can make an exception here. We can carve out this protection for personal liberty without jeopardizing this principle that we have of allowing broad regulation of the economy. And that's how we ended up with this two-tier of liberty. We have the preferred freedoms, which is what they're called: freedom of speech, freedom of press, and the right of privacy. Not the right to keep and bear arms, as it turns out. That's not a preferred freedom. And then we have these, dispreferred freedoms, economic liberty. Why? Because the regulation of the national economy from the New Deal to today has been thought to be of supreme importance. And neither the left nor the right really wants to undo that.
Do you think it was a flaw of the founders that they used the 9th and 10th Amendments as they were intended to sort of be these catch-all amendments, I guess, to say, hey, we've listed a bunch of rights here, but there are still other rights that the people have, that the states have, that we're not listing. And the fact that we haven't listed them doesn't mean that they don't exist. Should they have listed more liberties? Because the 9th and 10th Amendment, as you've talked about, as you've written about, have sort of been written out of the Constitution. And in, I think it was New York versus United States, one of the justices wrote that the 10th Amendment is a tautology. It's a
truism.
Truism, correct. But
they've been saying it for a long time.
Right.
It's a truism. Since the New Deal, they've been saying it since the New Deal, actually. It's a truism because it's part of this broadening of the federal power. Sure. This is like every breach of contract case. There's hardly any breach of contract case that would actually arise or be in a contract's casebook if the contract only said X. If only you'd put that in the contract, this wouldn't have happened.
Right.
So that's why contracts, by the way, get super long, because everybody thinks, well, next time I got to have this in there. So there's another clause and another clause and another clause, right? Because there's all these different ways of getting burned. So sure, it would always be easier to go back and say, oh, they should have put more in. But look, you can't put everything in. And Madison thought he'd fix the problem of not putting everything. And the Federalists objected to putting anything in because they said if you put anything in, there are people are going to say, well, those are the only rights you have.
Right.
And so all the other rights are going to be surrendered up to the general government. Madison thought he'd address that problem with the 9th Amendment, saying, look, just the fact that we put it in here doesn't mean you don't have any of these other rights. But that didn't work. The 9th Amendment hasn't worked. The 9th Amendment was good, but it hasn't worked because it's been ignored. On the other hand, it's better that we have the few rights they did put in than we have no rights at all. If there had been no freedom of speech put in there, if there had been no press or assembly or free exercise of religion, or the right to keep and bear arms, then I don't think we would be enjoying these rights to the extent that we have been. So yeah, it would be better if they had put in more. They got a second crack at putting in more in the 14th Amendment, and then they decided to do the same thing by not being specific. So they say no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. But they didn't tell us what the privileges or immunities was. And so the courts could say, oh, forget about it. That's too indefinite. Go away. Don't bother us. Even though that sounds like a pretty important provision. Think about it.
Right.
No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Wow. And yet it's never been used. It's been used one time in 130 years.
And would you lump that in with the 9th and 10th Amendment, that they're just so broad that it's easy for the court to dismiss them?
Yeah, because they say, well, it's not our job. We can't tell you what it means. Or right. In the slaughterhouse cases in 1873, 5 years after it was enacted, I think the court knew what it meant, and I think they didn't care for it. And so they just basically reduced it to nothing, and in a 5-4 case. And it's been nothing ever since they did that, except in the McDonald case, which was a right to keep and bear arms case, decided applying the right to keep and bear arms to the states. And 4 justices decided it under the Due Process Clause, but 1 justice, Justice Thomas, decided under the Privileges or Immunities Clause. So the Privileges or Immunities Clause is responsible for the 5th vote in protecting the right to keep and bear arms from state infringement.
Do you see it gaining any more steam after that?
This gets me back into the prediction mode.
I'm sorry. I can't help it.
But I will say I have no reason to believe, look, I have some reason to believe that some justices would like to reorganize their doctrine around the Privileges or Immunities Clause with respect to enumerated rights. The First Amendment, freedom of speech, freedom of, I think there would be 3 or 4 justices, or 2 or 3 justices, who would be amenable to that. What I don't think is that we have justices amenable to protecting unenumerated rights. And the reason why the justices haven't been willing to protect the enumerated rights that way is because the same evidence that shows that they were that the Privilege and Immunities Clause protected rights like freedom of speech, press, and assembly, that same evidence shows that the privileges or immunities of citizens included the right of contract and the right to have to own property. And they don't want to go there because that violates their principle that there should be strong national power to regulate the economy. So they are putting their principles ahead of the original meaning of the text of the Constitution, in my opinion.
Is there one case or one opinion in here that you would say this is perfect judicial reasoning? This is exactly how the Constitution should be interpreted?
Oh, wow. It's so funny because most of these cases are not like that. There's cases where the results are right, but the reasoning may not be as good as it should be. And then there's cases where the reasoning, are you asking about whether they've used the right reasoning or they've simply reached the right result?
Give me both.
Well, they've reached the right result quite a bit, actually. A lot of substantive due process cases reach the right result, but they should be done under the Privileges or Immunities Clause. The protecting the right to keep and bear arms against the states was done under the Due Process Clause. It should be under the privilege. So that's the right result.
Right.
In terms of the right reasoning, I mean, Heller is an example of an originalist opinion that I think was reasoned correctly. And I'd have to think hard. There haven't been that many that have been actually done according to original meaning. I mean, we recently had we had a very great opportunity to have a great case. It would be the recess appointments case, because you already asked me about that. And Noel Canning, because the original meaning really was pretty clear on the evidence. And 4 justices wanted to use the original meaning, and Justice Kennedy didn't. So he became the 5th vote with the progressives to say the original meaning was unclear, and therefore we should use tradition and whatever else they used. So we came really close. I think Justice Scalia, I think it was Alito or Scalia's opinion in Noel Canning. I forget who wrote the concurring opinion. It was really good. And that should have been the majority opinion, but it wasn't. I think if that case were decided today, it clearly would be the majority opinion. The case would come out the same way, and the opinion that was the concurring justices would be the majority opinion.
So we're almost out of time, but I have to ask you about my former professor and the newest member of the Supreme Court, Amy Coney Barrett. I know you worked with Senator Rand Paul when he was working on questioning her for her nomination. I was curious to get your thoughts on her as a nominee, and I know she's only been on the bench for a few months, but if you have any thoughts about how she's done so far on the bench.
Well, I'm a big fan of hers. Senator Paul asked me if I would sit in on his interview of her, and I, as he had asked me to sit, I also sat in on his interview with Brett Kavanaugh, both of which were very interesting. I think Justice Kavanaugh was a little more forthcoming than Justice Barrett was, but I also think he needed to be. So there's that. But I know Judge Barrett from when she participated in a conference on my book, Our Republican Constitution, at the University of Illinois. She wrote a paper criticizing my book. And she was there at the conference. And that's the first time I've seen her at conferences before, but that was the first time I spent any time with her, was during this weekend conference at Illinois. I was very impressed with her. She didn't agree with my book precisely on many of the issues you and I have talked about. economic liberty, whether there should be judicial review of that kind of stuff. She really disagreed with all that. At the very end of her review, she does agree with me about one thing, and that is that Justice Roberts had distorted the Commerce Clause, he had distorted the statute in order to uphold the Affordable Care Act. That was just a basic agreement with you. It was at the end of the article. During her confirmation hearings, she was continually questioned about that one part of the article in which she agreed with me. All the parts of the article which she disagreed with me about, everybody was cool with, because that was fine. But the one place she agreed with me, she took a lot of heat for it, and she ended up actually mentioning me in the hearings as, well, that was an article about Randy Barnett's book, and then she got the name of the book wrong. She called it Our Lost Constitution, as she combined both book titles together.
You thought, damn, that was my shot. That was my shot to get in front of.
Well, I got a lot of positive feedback from the name check, so that was fine. But it's sort of ironic and when I met with her in Senator Paul's office, I apologized for being responsible for having that review of my book, that criticism of my book being the subject of so much grief for her. She says, well, if it hadn't been that, it would have been something else. Right, so she took it in good stride. I think very highly of her. I'm glad to see her on the court. But I think, like the other conservatives, who I also think highly of, their judicial philosophy is not 100% mine. And so they may be originalists, they are originalists, but they have a view that I disapprove of. And I explain in the book that Justice Barrett disagreed with. I know she doesn't agree with me because she said she didn't agree with me. And I think she's not alone in not agreeing with me. And so I'm enthusiastic about the new justices, but with some qualification that they don't go all the way.
So I lied. I have one more question because you brought something else up. During her confirmation, there was a lot of talk about originalism, and so many people seemingly nefariously were presenting this strange view of originalism that's not what anyone who believes in originalism believes. Do you think that it was just a misunderstanding that people don't actually know what originalism is, or was it just people trying to smear Judge Barrett and just the idea of originalism?
Well, in many cases, they just don't know. And they should know. I mean, constitutional law professors don't know, and they should know better. I don't blame the general public for not knowing, but they're not the ones responsible for the smearing. The smearing is being done by people who should know better. And frankly, I don't know for sure whether they know better or not, but I give them the benefit of the doubt by saying that they're ignorant rather than deceptive. But that's itself a fault. I think it may be understandable because originalism has developed a lot in the last 20 years, and you'd have to keep up with matters to keep up with that. And maybe they don't keep up, which I know they don't keep up because that's why they don't know it. But it's, the job of the Georgetown Center for the Constitution to bring knowledge of originalism to a wider audience. And that also means explaining even to originalist justices what originalism actually demands of them. Judges, not just judges. So the Trump administration, the Bush administration did not screen for originalists. It screened for conservatives who might be restrained or other kind of conservatives. It's the Trump administration that screened for originalists, and to their credit. And a lot of judges have gone on, and they are originalists in good faith. They may not completely, fully know what that means and what that requires of them. So we who are originalist theorists and scholars need to speak with them, and because they want to do the right thing, it would be useful for them to know the theory. This is where we get back to theory versus practice. This is really where we started our conversation. The theory is important, because it might say, well, you want to do this, but you shouldn't. The theory says you really shouldn't be doing this. You should be doing this. And if they don't know the theory, they might do this because it sounds good. So theory, the technicalities are important. And it's the job of the Georgetown Center for the Constitution, as well as others, but this is one of our missions, is to bring knowledge of what originalism really requires to the attention of judges who really want to do the right thing, but they may not do the right. They may make a mistake because they're not sure. Or they may think they know and they don't.
Right. Well, Professor Randy Barnett, thank you so much for your time. I appreciate it. The book is An Introduction to Constitutional Law, 100 Supreme Court Cases Everyone Should Know. It really is a great read, whether you're a lawyer and you're trying to brush up on constitutional law, whether you're just a regular person who's just interested in these ideas. It reads like a history book in the best sense. It's you can flip
It's
through
a storybook. Don't say history book. Say story.
Storybook. Sorry, story. But that's really what it is. You bring to life these cases and the people involved in them. I highly recommend it. I highly recommend.
Can I say?
Please.
Can I say one more thing about that? And then I stepped on you telling people to follow me on Twitter. But the one more thing is that I talked a lot about the videos, but people have a hard time finding the videos. People who are not tech savvy. So you buy the paperback, you open the paperback, and on the inside of the cover is a scratch-off code, good for access to the videos. And so you go to the website and you scratch and you put the code, and then you'll be able to get the videos. So you need to know to do that. We're hoping for the next edition, we can figure out a way for the videos to be more easily accessible to people who are not as used to doing scratch-off codes and that sort of thing. And we're having a hard time with our publisher getting them to do that. But that's partly because it costs so much money to make the videos, we can't make them publicly accessible. We have to charge for them. So anyway, I just want everybody to know the videos are really, I think the book is great. I'm glad you like the book too, Eric, but the videos is what we put our heart and soul into, because there's a lot of graphics and illustrations. There are sound recordings of the justices handing down their own statements. There are excerpts from oral arguments. You will really love the videos, but you can only get to the videos if you know how to get to it, and that is by using that code on the inside cover.
Yeah. And
Now I'll let you finish promoting me.
No, I'll build on that. I love those videos. I watched a few of them. They really are well done. They're interesting. So if you don't feel like reading the book, I absolutely recommend the videos. But yes, I was going to say, please follow Professor Barnett on Twitter, because he is one of the most fun people to follow. It's interesting. It's insightful. I stay off of Twitter. There's so much negativity on Twitter, but you're one of the few people I enjoy following.
So what makes my Twitter feed fun, do you think?
I think your willingness to engage with people, because again, like I said, there's a disconnect that even other academics on Twitter seem to want to only engage with other academics, but you're willing to engage in these academic discussions, but also just talk to regular people and just kind of post funny things. You let your whole personality shine. I think that's the most interesting thing.
So it's not my posts of music videos like from.
Exactly. Well, where were you? You were just posting. You were posting about. Oh, I forget what it was. There was something you posted just the other day, and I thought you made me laugh.
Tom Petty and the Heartbreakers. There was a video on him, and
Right.
and ELO, the great cover of Roll Over Beethoven, Electric Light Orchestra. Basically, I'll be watching YouTube, and I'll be saying, I just need to take a break, and there's some videos that are my favorites, and so I'll just watch them, and I go, I'm going to share this video.
Yeah.
Why not, right?
Exactly. Well, and that's again, I think that's letting your whole personality shine. I think makes you more accessible to people, and again, they'll start following you for that, and maybe they'll start reading about Lysander Spooner. Who knows?
Well, thanks, Eric. Thanks for having me on. This was a great interview. You did a great job.
Thank you.
And I enjoyed it a lot.
All right.